Hello, welcome to Sleepy Galaxy Tales. My name is Reggie. Tonight I will be reading from the Federal Register. These entries are formal, procedural, and not important to remember. You do not need to follow along. You do not need to understand any of this. If you find these readings helpful, you may choose to like this video or follow the channel so you can find similar readings again. For now, you can simply rest and let the register continue. I will begin. The Federal Register, Volume 60, Number 1, Tuesday, January 3rd, 1995. Rules and Regulations, pages 2 through 3, published by the Government Publishing Office, document number 94-32288, Department of Agriculture, Title 7 of the Code of Federal Regulations, Part 966, Title Tomatoes Grown in Florida, Expenses, and Assessment Rate, Agency, Agricultural Marketing Service, United States Department of Agriculture, Action, Final Rule, Summary. The Department of Agriculture is adopting as a final rule without change the provisions of an interim final rule. That interim final rule authorized expenses and established an assessment rate to generate funds to pay those expenses. Authorization of this budget enables the Florida Tomato Committee to incur expenses that are reasonable and necessary to administer the program. Funds to administer this program are derived from assessments on handlers. Effective date. This rule is effective from August 1st, 1994 through July 31st, 1995. Supplementary information. This rule is issued under Marketing Agreement Number 125 and Order Number 966, both as amended. Title 7, Code of Federal Regulations, Part 966. The order regulates the handling of tomatoes grown in Florida and is effective under the Agricultural Marketing Agreement Act of 1937 as amended. Title 7, United States Code, Sections 601 through 674. This statute is hereinafter referred to as the Act. The Department of Agriculture is issuing this rule in conformance with Executive Order 12866. This rule has been reviewed under Executive Order 12778, Civil Justice Reform. Under the marketing order, Florida tomatoes are subject to assessments. The assessment rate issued here applies to all assessable tomatoes handled during the 1994 through 1995 fiscal period. This fiscal period began August 1st, 1994 and ends July 31st, 1995. This rule will not preempt any state or local laws, regulations, or policies unless they present an irreconcilable conflict with this rule. The Act provides that administrative proceedings must be exhausted before parties may file suit in court under Section 608C, subsection 15, paragraph A of the Act. Any handler subject to an order may file a petition with the Secretary. The petition may state that the order, any provision of the order, or any obligation imposed in connection with the order is not in accordance with law. The handler may request a modification of the order or to be exempted from it. The handler is afforded the opportunity for a hearing. After the hearing, the Secretary would rule on the petition. A United States District Court in any district where the handler resides or maintains a principal place of business has jurisdiction in equity to review the Secretary's ruling. A bill in equity must be filed not later than 20 days after the entry of the ruling. Pursuant to the Regulatory Flexibility Act, the administrator of the Agricultural Marketing Service has considered the economic impact of this rule on small entities. There are approximately 250 producers of Florida tomatoes and approximately 50 handlers subject to this marketing order. The majority of these producers and handlers may be classified as small entities. The budget of expenses for the 1994 through 1995 fiscal period was prepared by the Florida Tomato Committee. The committee is responsible for local administration of the marketing order. The budget was formulated and discussed at a public meeting. The committee met September 8, 1994, and unanimously recommended a budget of $2,215,000. This amount is $467,000 less than the previous year. The committee also unanimously recommended an assessment rate of 4 cents per 25-pound container, the same as the prior year. This rate, when applied to anticipated shipments of 55 million 25-pound containers, will yield $2,200,000 in assessment income, along with interest and other income. This amount is sufficient to cover budgeted expenses. An interim final rule was published November 3rd, 1994. No comments were received. The administrator of the Agricultural Marketing Service has determined that this action will not have a significant economic impact on a substantial number of small entities. List of subjects in Title VII, Code of Federal Regulations, Part 966, Marketing Agreements, Reporting, and Record-Keeping Requirements, tomatoes, for the reasons set forth. In the preamble, Title VII, Code of Federal Regulations, Part 966, is amended. Accordingly, the interim final rule, published November 3rd, 1994 is adopted as a final rule without change, dated December 27th, 1994. This concludes tonight's reading from the Federal Register. Thank you for listening. If you are still awake, you may like this video or follow Sleepy Galaxy Tales for more calm readings. Otherwise, you may continue resting. Good night.